I'm sorry. I'm Bart Daniel, and seated next to me is Elle Klein. We're with Nelson Mullins, Raleigh, and Scarborough, based in Columbia, but we actually have a nationwide practice, as most of you know now. Particular focus today is going to be on fraud and oversight challenges from the CARES Act and the Paycheck Protection Program. First, I want to give you a little bit about my background, so you'll at least think you'll know what I'm talking about. And that background is when I finished law school in 1980. I had worked there in law school, and then I was hired under an economic crime grant to prosecute white-collar crime cases. So most of the cases I did, as you can imagine, were smaller fraud cases in state court. My boss, John McIntosh, was hired over at the U.S. Attorney's Office to head up the criminal division, and he dutifully brought me over there with him. So I began as an assistant U.S. attorney, and I did that for about 4 years, prosecuting financial crime cases, fraud, and the old Operation Jackpot. I did the financial part of those cases too. After I left the U.S. Attorney's Office after those 4 years, I went to private practice for about 3 years, 3.5 years, and then was appointed by the first President Bush as United States Attorney for South Carolina, which I did for over 3 years, and then returned to private practice. And I've been in private practice. My focus is on defending government investigations and also the False Claims Act. So mostly criminal and civil, but government investigations. And so I get to work a great deal with, after coming to Nelson Mullins, with Elle Klein. So I'm going to turn over to Elle and let Elle give you some of her background. Elle?
Yes, I am Elle Klein. I graduated from USC in 2018 and joined Nelson Mullins right after. My practice focuses mainly on automotive distribution and franchise litigation, but I have the honor and privilege of working with Bart on a regular basis, and we're very excited to go over this presentation with you today.
Well, I want to go over the agenda with you so you'll have a little bit of a feel for what we expect to cover today. First of all, we'll give you an introduction to fraud investigations, and we'll talk a little bit about that, and particularly answer the question, what is the driving force behind aggressive Department of Justice enforcement? What's the driving force behind the DOJ and the Department of Treasury as far as investigating cases? We're going to also talk about some past lessons. And you said that the TARP program, which was the Troubled Asset Relief Program, was funds given to troubled financial institutions, and financial institutions were the ones that were targeted. And it created the enabling legislation, created an oversight committee, and also created what they call known as SIGTARP. And that's very important because SIGTARP is the Special Inspector General for TARP funds. So those institutions that receive the TARP funds could be subject, and many were, to a special Inspector General's investigation. And I was fortunate enough, fortunate for myself, but not so much for my clients, to have 3 of those financial institutions. One was sort of an international financial institution, and one was a sort of a mid-level, and the other one was a local community bank. And it dragged on forever and ever and ever. And I think there are some past lessons to learn from the TARP program and the SIGTARP, particularly the types of investigations they had. Elle's going to talk to you then about the current program, particularly the statutory makeup and the impact of the CARES Act and the Paycheck Protection Program. I'll chip in right along that, not long after that, with the False Claims Act, because that's going to be really important in the coming years with the enforcement of the Pandemic Recovery Office of Inspector General. That's going to be their primary focus, the False Claims Act. And you know the old saying, where you find the money, you find the plaintiff's bar, and the plaintiff's bar will find the whistleblowers. So, and then they're also going to look at some of the recent enforcement already under the COVID-19 fraud. And what I've seen on a daily basis, actually, with the Department of Justice, is I've got clients that are cooperating, who are under investigation and currently cooperating, or were under indictment and cooperating. And the Department of Justice and the assistant U.S. attorneys from around the country are saying to me, look, if your client can help us with this COVID-19 fraud that's all over the internet, then that would go a long way to helping them get a reduced sentence or perhaps we'd be able to recommend supervised release, which is no sentence at all. So then we're going to talk to you in closing about precautionary measures, and then I'll wrap up the program. I also talk to you about that. Then I'll wrap up the program at the very end with 4 significant takeaways, things you want to remember to be able to protect you as corporate counsel, particularly to be able to protect your organization. So without further introduction, we look at the fraud investigations and how they begin. And so we look at, well, why such aggressive and fraud enforcement under the CARES Act? You know, sometimes a little explanation can be a very short story. And Willie Sutton was a notorious bank robber in the 1930s. He robbed a string of banks all across the country. They couldn't catch him. And when the FBI finally tracked Willie Sutton down, he was going to court. And a reporter, there was a mob of reporters outside the courthouse, and they asked Willie Sutton, they said, Willie, why do you rob banks? And he said, simple, because that's where the money is. And that's the answer that brings us here today. $2 trillion in aid. Whenever the government spends significant funds, you're going to see a significant enhanced fraud enforcement. Just talk to any of your buddies that are on this particular call, on this program, listen to this program, who are in the healthcare business. Because any healthcare provider or anyone, whether it's a DME, durable medical equipment provider, or a hospital, they all deal with these investigations from time to time. So the question becomes, how does an investigation begin? And what I've done is I've ranked them sort of under the least invasive, if you will, to the most invasive. Least invasive being an independent audit under the Recovery Contractor Program. It's called RAC. It only applies to healthcare providers. So it doesn't apply to the rest of us, but this does apply to them. And the RAC is an outside auditor, but they're in the business of auditing healthcare providers, and we call them bounty hunters because they get a 30% bounty on whatever overpayment that they find. So the next you would see that applies to certainly to your business and other businesses, as a matter of fact, as individuals, is an agency, whether it be the FBI or HHS or Department of Defense or Department of Justice, issue what's known as an administrative demand. You may get one from the IRS where they ask you to answer questions, almost like interrogatories, or to produce documents. Next would be a civil investigative demand, and that's much different than an administrative demand, although they sound similar. They're not. A civil investigative demand has to be signed by an assistant United States attorney, and it's by a civil assistant United States attorney, and that really came about in the last few years. And what that is, it gives the U.S. attorney the power, without the use of the grand jury, it gives the civil division at the U.S. Attorney's Office to use in civil cases these civil investigative demands. They can do 2 things. They can request or require you to produce documents, number one, but like a grand jury subpoena, they can also compel testimony. And what you do then is you go to the U.S. Attorney's Office, there's a court reporter, and you give sworn testimony. Unlike the grand jury, you get to have your lawyer sitting there with you. We'll talk about the grand juries in a minute. Next, you learn about investigations because an agent comes knocking at one of your employees' door during the dinner hours after they've gone off to work from a long, hard day. They're tired. They pick the children at the supper table, and they come knocking at the door, and they want to interview. And that's your most vulnerable time for your employees. They want to catch them when they're away from the office. And this is not something that happens every now and then. It's a tried and true, and it's been going on for years and years. It's a tried and true method of investigation. And usually they'll get the person who wants to obviously to rejoin the dinner table with the family. The person will agree to meet them or to call them to meet them the next day or within the next couple of days. If you're in-house counsel, you want to know about that. And you want to tell your employees in general before anything ever begins that if you ever get an agent knocking on your door, you want to make sure and want to ask questions, you want to make sure you report it to us. Now, the advantage of that is that you can set up an interview. It can be orderly. Your in-house counsel can be there. You should also have outside counsel there. And outside counsel sort of keeps the agent honest for one purpose. And the other purpose is they can prepare the witness so that the witness gives answers that are within context to make sure the agent understands the fullness of an answer and doesn't get a half of a picture or something taken out of context. So you next have your grand jury subpoena. As I mentioned, that's to compel testimony. It can be for documents, but we think more of witnesses sitting before the grand jury. Grand juries are comprised of no less than 16 citizens, no more than 23 citizens. You have to have that quorum in there, at least 16, in order to be able to take testimony or to take any action on an indictment. Next is a target or a subject letter. And we're getting to the more serious each time. Each step of the way, we're getting to something more serious. And this is more serious because if your company or your CEO or someone in the C-suites gets a target or a subject letter, it means the U.S. attorney, it'll say right in the letter, you're the subject or the target of a federal grand jury investigation looking into allegations of fraud. If you get that kind of letter, you'll know there's a problem and you need to deal with it. You need to get counsel to deal with it, outside counsel to deal with it right away, because it means they intend to indict you or intend to investigate your organization. And finally, the most invasive technique, the most invasive way you learn, the most apparent way you learn of a federal investigation is the execution of a criminal search warrant. And that's when agents come in with an overwhelming show of force in order to prevent any trouble, and they execute the search warrant, usually either seizing computers or imaging computers. And many times they will try to talk with your employees at the same time. So that's sort of the investigations and how they begin. Now, let's look at, this is entitled Learning from the Past, and it's TARP's three-pronged oversight. Elle, you want me to cover that? Okay. So TARP is to protect the TARP program to what they did back 10, 15 years, I guess it was passed in 2008, to create the Financial Stability Oversight Board, a Congressional Oversight Committee, and a Special Inspector General for TARP funds. As I said in the introduction, it's remarkably similar to what we're going to see under the CARES Act when they have a Special Inspector General set. But TARP, unlike the CARES Act, is limited or was limited to financial institutions. Only financial institutions received TARP funds. And in addition, the initial allocation for TARP, while was initially $700 billion, that got whittled down when it was finally enacted down to $475 billion. Still a tremendous amount of money, but not the $2 trillion that was allocated to the CARES Act and the stimulus plans that are related. So there is a market contrast. And of course, along with that is CARES Act is not limited to financial institutions. It's companies, both large and small, all across the fruited plain. So as you know, with government money comes enhanced scrutiny. And under TARP, we saw that the regulations were aggressively enforced. And investigations became the norm for any financial institution that took TARP funds. And even to date, and remember, this got passed back in 2008. It was supposed to end initially in like 5 years, and then Congress extended it, and it's still going today. 438 individuals were criminally charged following these SIG-TARP investigations. 381 were convicted, and 300 of these defendants, including 76 bankers and 92 bank borrowers, were sentenced to prison terms. It also resulted in enforcement actions against 24 companies, as you can see. Want to give you a magic word now?
Yes, sure. So as part of getting your credit for this CLE, on your certification page, you're going to have to put 3 magic code words. And so your first magic code word for this afternoon is the word blue, as the color blue. And so Bart was talking about TARP, and we understand that history has a habit of repeating itself. So if we fast forward today, we're going to see 2 main mechanisms of enforcement, being the CARES Act, or the Coronavirus Aid, Relief, and Economic Security Act, in which the Paycheck Protection Program, which I'll refer to as the PPP, as well as the False Claims Act, are going to come into play over the next couple of years. And we already know that the CARES Act has come into play within the last couple of months. So the CARES Act was enacted on March 27th of 2020. It provided, as Bart said, over $2 trillion of economic relief. And it's very lengthy and provides an array of support, but we really are going to focus on the Paycheck Protection Program because that's what's impacting our clients and the people on this call the most. The Paycheck Protection Program, or the PPP, was created in Title I of the Act, which is Keeping American Workers Paid and Employed Act. This was a $349 billion program that was made available through the Small Business Association. And these programs were designed to keep employees on the payroll and give employers a loan to help them cover those costs. Now, the PPP was available to small businesses, and small businesses is defined in the Act as less than 500 companies. However, there's also additional caveats. For example, restaurants, hotels, and businesses that fall within the NAICS, or the North American Industry Classification System, Code 72, which is titled Accommodation and Food Services, were also available for the Paycheck Protection Program. So for example, the Marriott in Charleston would be eligible for the PPP, as well as the Marriott in Columbia and the Marriott in Greenville. So even though we historically think of them as big corporations with well more than 500 employees, it looked at the individual locations of each of those businesses. There were several other nuances to the PPP, but for the time being, those are the most important information that you need. And the purpose of this is to allow an employer to maintain a payroll for up to 8 weeks. And if he did so, loan expenses would be forgiven. And in particular, payroll would be forgiven up to $100,000 per employee, as well as mortgage interest, rent, and utilities. How much could ultimately be forgiven is dependent on whether or not that employer used the funds appropriately, as well as how many employees stayed employed during that time period. But big corporations also got some relief under Title IV of the CARES Act, which is entitled Economic Stabilization and Relief to Severely Distressed Sectors. Our big corporations got some relief. So $25 billion was allocated to our airlines or our air carriers, aviation repair stations. And over $454 billion was given to support the Federal Reserve's lending facilities. And those were targeted at helping our mid-size or larger businesses, so 500 to 1,000 employees. But as we know, with great power comes great responsibility. And in this case, it's going to be having the responsibility to report accurately and to expect some oversight or be compliant if an investigation arises. So there are three key players in the oversight game for CARES, and Bart talked about a couple of them as they came up in TARP. But here, much like we had the SIG TARP, we have the SIG PR, who is the Special Inspector General for Pandemic Recovery, SIG PR, and he was tasked under the Act, or she, with auditing and investigating CARES Act loans and investments. The SIG Act, or the SIG PR, is appointed by the President with advice and consent of the Senate. And under the Act, he is directed to conduct, supervise, and coordinate audits and investigations of Title IV, which we know as the PPP, of the CARES Act. He's also tasked with auditing and supervising any other programs that the Treasury decides to establish under the Act. He's required to maintain certain information and provide reports to Congress periodically, and his term will end in 2025. That is, of course, unless it's reenacted in that interim.
And you can bet that's going to be extended because that's what happened with the TARP program. In addition to, as Elle was talking about it, it also provides for funding for prosecutor positions both at the Department of Justice in Washington, but more so out in the field at the various U.S. attorneys' offices. It also funds additional auditor positions and additional criminal and civil agent positions, so they can have better, so prosecutors can better investigate and prosecute these abuses.
Yeah, in fact, he was given $25 million in discretionary funds to hire new auditors and agents specifically for CARES Act fraud. On June 2nd, the Senate confirmed Brian Miller to serve as SIG PR, and based on some statements that he's made already, he's said that he is going to conduct every audit and investigation with fairness and impartiality, but be vigilant to protect the integrity and independence of the office of the SIG PR. So we've already seen him start to, we expect him to hire more robustly these law enforcement agents who will then begin their own investigations. So in addition to the SIG-PR, we also have the Pandemic Response Accountability Committee. This is another committee established under the CARES Act, and they're in charge with coordinating, supporting the oversight of all federal pandemic relief programs. And they were given an $80 million budget by Congress. The acting chair of this is our DOJ Inspector General, Michael Horowitz, and it's composed of 10 inspector generals from other agencies. And these are very large agencies. We have inspector generals from the Departments of Defense, Education, Health and Human Services, Homeland Security, Labor, and Treasury, as well as the Inspector General from the Small Business Association or Administration, and the Treasury Inspector General from Tax Administration. This is a standalone organization, and it was created as a committee of the Council of the Inspector General of Integrity and Efficiency. And much like the SIG-PR, they actually also have the ability to issue and enforce subpoenas and hold public hearings. And lastly, we have the Congressional Oversight Committee. And the CARES Act established this commission, or excuse me, the committee, to oversee the Treasury and Federal Reserve's implementation of the stimulus package. And this was comprised of 5 members selected by the majority and minority leadership in both the House and the Senate. And like the other accountability branches, they're responsible for providing reports and detailed investigations as to how these funds are being used. And like TARP, they are currently scheduled to terminate in 2025, but as Bart said, we would expect to see that extended much like TARP was.
Yeah, and that go back to that special inspector general for pandemic recovery. That's what most of us are concerned with today. Most of you should be concerned with today, because that's at the macro level. That's sort of where the rubber meets the road, where your playing field and my playing field. So we don't want anybody to see any pandemic recovery inspector general folks, but you very well might if you took money for the pandemic recovery.
And I think it's worth mentioning, in addition to being able to obtain and execute search warrants and subpoenas, they're also allowed to execute arrest warrants. So the bottom line on this, though, is that we have a lot of people looking at recipients of CARES Act relief. So enforcement is coming. It already has started. We expect to see more robust and active enforcement over the next couple of years. And we know this, in addition to the indictments that we've already seen, is just the strong statements that have come out of the people of power and the people with the oversight on these various areas. For example, the DOJ has made it clear that they're going to take swift action against any individual or entity who fraudulently takes advantage of CARES Act funds. On March 16th, U.S. Attorney General William Barr wrote, "It is essential that the Department of Justice remain vigilant in detecting, investigating, and prosecuting wrongdoing related to COVID-19. So setting aside the fact that this is a $2 trillion package, what makes CARES Act an easy target for investigators, or an easy way to slip up, is there's a lot of self-certifications within these applications. And the application in these submissions that have these self-certifications make them right for government if they suspect that someone is misrepresenting to come in and conduct an investigation. And these misrepresentations could be a mistake or with an ulterior motive. And at this time, I'm going to give you your second magic word of the day, which is pink, the color pink. Again, pink. These false certifications could also subject borrowers to liability under the False Claims Act, which Bart is going to talk about here shortly.
Okay, and what we look at here is an SEC investigation. So publicly traded companies, beware, because the SEC has somehow gotten its claws into the CARES Act as well. And what they're going to be looking at to see is how businesses used the Paycheck Protection Program, particularly if we go back to the application, and did they use it the way when they applied for it? Did they materially misrepresent something or fail to disclose something to the program, to the SBA? And also that means that they did not disclose everything to potential shareholders or to potential investors, or did they use the money from the Paycheck program? Did they use those funds for something other than set out for the program? And if so, did they also mislead their investors to how they use the money? And they could be prosecuted, as you know, for COVID-19 fraud, but also for securities fraud. And we won't spend too much time on that, but just note the SEC. You won't see it as active as you will see the Inspector General for Pandemic Recovery, but still the SEC is looming out there for those of you who are involved in working with publicly traded companies. The SBA actually has got much of the oversight of these investigations, or at least working with the Inspector General. But the SBA and Department of Treasury will conduct investigations. And so you know the SBA has its own Office of Investigations. And so I deal with them all the time, quite frankly, with the various SBA programs with recipients, small businesses and large businesses, but those who are considered small businesses actually receive different funds from different programs. But the SBA and the Department of Treasury, through its strong arm of the IRS, will conduct investigations of all borrowers with loans exceed $2 million. Now let's read that one more time. It's going to conduct. It's almost like shall. If your company received over $2 million in CARES relief, then you will be investigated. I didn't say audited. I said will be investigated, and that's significant because normally before the FBI or Department of Treasury, IRS, or Department of Justice, any of its subsidiaries, normally before investigation begins, the FBI agent, for instance, or the OIG investigator has to go to the U.S. Attorney's Office and run it by, get the approval of to open a file of an assistant U.S. attorney, a federal prosecutor. But as you see, in this case, they don't. They can begin, they're required to begin their own investigation. And you better believe they've already got a list right now of those companies which took more than $2 million, and they're considered small businesses still. And I can promise you these investigations have already begun. And it says these agencies will also conduct additional reviews as appropriate. We don't have too much details on how that's going to play out because we haven't seen that so much in the past. I think my experience with the SBA and their criminal investigators or criminal agents is about the closest I can come to telling you, and that's not much different than the FBI, the way they conduct investigations. Now, one thing that's different about this enforcement part of it, and the reason why you can see not just the Special Inspector General, you've got the specter of that hanging out there, but you've also got a much bigger lion, if you will, or a much bigger problem, and that is the problem of whistleblowers. Because as I said before, wherever you see the money, you find the plaintiff's bar, and the plaintiff's bar is going to find the whistleblowers. And you remember, my boss told me one time, if for no other reason you should treat your employees nice, is because that disgruntled employee today becomes a whistleblower of tomorrow. And so that's why I always recommend that companies, particularly providers, set up hotlines. So that an employee hotline, so that they can, if they see something, they see some fraud, or they see something that doesn't look quite right, they can report it without their supervisor, or without the CEO, without anybody. We want somebody independent within the company to be able to review those tips, or those fraud tips, or any kind of any kind of sort of problem like that. So the False Claims Act, sometimes a page of history is worth, they say, thousands of volumes of law. The False Claims Act was enacted in 1863, and it was what happened was President Lincoln went to Congress because the providers of munitions, the contractors, if you will, of the day were selling many times faulty munitions to the government, to the War Department. And the War Department had soldiers out in the field that were in harm's way, and they could their weapons wouldn't fire, or they would misfire. So President Lincoln, in the middle of the war, went to Congress and said, we've got to do something. So Congress passed the False Claims Act. And what it did, it made a civil remedy for submission of false claims to the federal government. Now, there's also a criminal component to it, which is federal program fraud, and that carries a 10-year imprisonment term and $250,000 fine. But that's not going to be the big problem for businesses. The big problem for businesses is going to be the False Claims Act, the civil provisions of it. And we're going to see that the False Claims Act, when it was passed, really, it had no teeth. And really, at the U.S. Attorney's Office, I was an assistant U.S. attorney in the early and in the mid-'80s until 1986. And I prosecuted civil and criminal fraud cases. I never used the False Claims Act because the False Claims Act really, it had no teeth. You know, it had no real enforcement powers. But that changed over the years, beginning in 1986. First of all, in 1986, the burden of proof was lowered from clear and convincing, which is the burden of proof, as you know, in a fraud case, is the burden of proof is clear and convincing evidence. You have to have clear and convincing, you have strong evidence, right? Well, it was changed in 1986 to by a preponderance, or they say a greater weight, or maybe even a feather added to the scales of justice, a greater weight of the evidence. So it also established liability for deliberate ignorance and reckless disregard. And that's why, as you say, I say it obliterated the ostrich defense. I have another saying that the federal penitentiary is filled with ostriches. People that say they didn't know they did anything wrong. But these amendments remove the requirements that there should be specific intent. So it changed the whole thoughts behind the criminal justice system get sort of turned on its heels with the False Claims Act, because there's now no specific intent to commit the crime, if you will, or to commit the dastardly deed. The government only needs to show that the claim submitted is false and that it was submitted knowingly. And the damages are what one of the real problems, because they're travel damages and they're civil fines per claim. So if you had, you're a hospital, for instance, you might have 10,000 claims, and the fines, the civil fine, are anywhere between $10,000 and $21,000 per claim. And it's not discretionary with the judge. The judge has to find, if a jury finds there's a civil violation in any one of those payments, for that payment, the judge has to find at least $10,781. Could find more, but it's got to find a minimum amount of that payment. So you see the False Claims Act getting stronger and stronger, and you see the plaintiffs' bar, the relators' bar, all of a sudden spring to life after the 86 amendments. And then they even got livelier after the 2009 amendments, which amended the intent requirement to it only needs to quote material to the plaintiff. And then finally, the reverse false claim. And the reverse false claim says this: if you as a provider, if you as an entity, you see it in the defense industry all the time, I deal with a good bit. If you see where you made or you received an overpayment, someone made a mistake in submitting a claim for payment and you were overpaid, you've got 60 days to return that overpayment. If not, on that 61st day, you could be civilly prosecuted, but also something different again, criminally prosecuted. And cases are prosecuted under the Reverse False Claims Act. Elle?
So we've seen some recent enforcement regarding the CARES Act. To date, the Department of Justice has already initiated roughly 40 criminal or civil prosecutions throughout the state. And when we've gone through and reviewed these initial prosecutions, we see a trend coming up with how the DOJ is targeting these CARES Act fraud cases. They're really focusing on the false statements or representations made by the submitters as to the number of employees within the company, the earnings of the employees within the company, such as you're saying a secretary who makes $40,000 a year, and you're claiming that she makes $100,000 a year. And we also see cases involving misuse of funds. I'm going to talk briefly about three cases that we've seen so far. We saw our first DOJ CARES Act case on May 5th, and they filed charges against individuals who were alleged to have filed fraudulent applications for PPP loans. These two individuals claimed that they needed PPP funds for 4 restaurants that they owned up in Rhode Island and Massachusetts. And upon investigation, they found out that 2 of the restaurants, one of them pictured here, was actually closed prior to the pandemic. The 3rd restaurant, they falsely claimed to own and had no legal ownership in that entity. And then one of the individuals had been falsely using his brother's identity to make the claims. And lastly, so none of these companies or these 4 restaurants had any employees whatsoever. And they brought these charges in Rhode Island, and the U.S. attorney for the Rhode Island cited to Attorney General Barr's prior direction to prioritize these criminal conducts. And what's interesting and important is that this is actually a product, or this indictment was a product of a relationship and partnership with the SBA Inspector General's office and the DOJ. So they worked together to come to this first indictment. Another interesting case we saw was out of Atlanta, when the Department of Justice announced an indictment against Atlanta reality TV star Maurice Fain. He is a star on the show Love and Hip Hop, if any of y'all are familiar. And he allegedly misrepresented what he needed for the Paycheck Protection Program. According to the indictment, he submitted that he needed over $2 million in funds to pay his employees for a waste management company that he allegedly owns. And after he got these funds, he is reported to have used more than $1.5 million on personal expenses, including a Rolls Royce for $136,000. He had custom diamond jewelry made of over $85,000. Surprisingly, he paid off prior restitution in another fraud case.
Ooh.
And used remains of the fund for child support payments. And then a third recent enforcement action that we have seen came out of California, when a California movie producer sought $1.7 million in PPP loans to support the production of 3 additional films. And he has allegedly transferred over half of that money to his personal bank account and has used those funds to pay off personal credit cards and his car loan. So as we can see from these are obvious violations of the CARES Act and the use of the funds. And so we know that the DOJ and other enforcement agencies are really targeting the low-hanging fruit right now, and the people that are blatantly misusing the funds, such as buying Rolexes and Rolls Royces. However, as things really settle down and these agencies begin getting comfortable with the act and the enforcement they're under, we'll see them going after, 1, the smarter criminals, or 2, those who unintentionally misrepresented or failed to accurately report as required under the act. So knowing that this is coming, it is crucial for businesses to take the precautionary measures now to make sure they can avoid criminal and civil penalties later.
So precautionary measures. Be aware of any skeletons in the closet. What happens in investigations, whether it's a TARP investigation, whether it's going to be a pandemic relief investigation, or whether it's an FBI investigation, whatever the probable cause that gave the investigator, gave the agent and the prosecutor reason to be able to investigate the entity in the first place, when they go in there, they don't limit their investigation to that specific probable cause. They look around. We had an expression in our business that says, when the camel sticks his nose under that tent, they don't just look at one targeted activity. They look all around the tent. And if they see anything, they hear anything that's illegal, then that's what you will get prosecuted for that. So that's really, really important. So by accepting taxpayer money, businesses that had managed to hide prior bad conduct or ongoing conduct are suddenly exposing themselves to investigation and prosecution under the Pandemic Relief Inspector General. And then businesses, particularly in-house counsel, need to know their company's history of compliance. So if they have a problem, at least they know about it and they can try to deal with it. And what happens is this: we all know what happens. Companies have had problems in the past. They've dealt with them. They've kept them quiet. Some activity's been illegal or crossed the line, but they say, we need these funds to keep going, so we could take these funds anyway. And they say, really, we'll take the money now and worry about the investigations later. And it's got a good point, because not everyone's will get investigated. But if you do, If you do, then you better believe they're going to find that illegal activity. So what you want to do to take cautionary measures is you want to ensure accurate representation. You need to designate a CARES compliance officer, somebody in the company, and maybe you already have a compliance officer. You can give that compliance officer perhaps some additional responsibility. And as I said before, you need to have an employee hotline created, because in this day and time of whistleblowers being just all over the place, you need to have a hotline so people can let off steam and people can report what they think is fraudulent activity, and people can see some kind of action taken, or at least you get back with that person and say, we've investigated that activity and it wasn't exactly what you thought. We didn't find anything illegal about it. We didn't find where anybody crossed the line. Also, you need to know, top level of the company need to know what's going on, because you've got the application and you've got the certifications. The applications for the government money, it's got to be signed by a responsible corporate official, and you've got the certification at the end of it, and that is you certifying that you use the money properly, the way it's prescribed in the program. You cannot, the CEO cannot delegate this responsibility. Upper management will ultimately be held responsible. And you know the old saying, the buck stops in the C-suites. Prosecutors don't look to just prosecute a low-level employee. They climb the ladder as high as they can get, including the CEO, including perhaps the chairman of a board. So investigations, ultimately, when they get in there, there's nothing the agent and the prosecutor would rather do than be able to target the C-suites and be able to get some of the CEO, the CFO, or some such prosecutor. Elle?
A couple other precautionary measures that we can take is coach them up. You need to know when that money arrives into the company's bank account, what happens next? How is that money intended to be spent? Who's making the decisions on where the money is being spent? What controls or oversight is in place to verify how that money is being spent, and what documents support that decision? Bottom line, a business just needs to be very clear about what kind of spending they're doing, as CARES Act has very specific requirements, and sloppiness, or even worse, intentional misrepresentation of the use of those funds can result in civil or criminal penalties. In addition to creating these policies and controls, you should conduct training for all your employees. You know, policies are only as effective as the employees make them. And if employees and managers know what is expected of them, they can better perform. So we suggest developing a comprehensive training program so that those responsible for the funds distributed under the CARES Act and the related activities therein know the rules of the road and how to abide by them. And secondly, document everything. We have a lot of attorneys on this presentation, and we're pretty good at and meticulous about keeping a written record, but maybe our clients are not. And so we need to advise them to do so. Acting appropriately is only one part of a strong compliance program. Businesses really need to maintain good records of how these funds were used. They also need to maintain records in how they filled out these applications, and they need to include the supporting documentation for any representation that they made on those documents. We would encourage clients to keep a list of CARES Act requirements and to go through those and to make sure that they've complied with those along the way. And if you have any questions related to those, you can email Bart or myself, and we'd be happy to share. An easy way to keep track of PPP proceeds is just to set up a separate account for them. It would take away a lot of the record keeping and the document trail that is needed if it's in a separate account of its own, much like a trust account or an escrow account. And additionally, it would behoove our clients and us as lawyers to monitor for ongoing regulatory guidance and updates, just to know what the DOJ, what the SIG-PR, who they're going after and what they're going after, to ensure that you're being compliant with the CARES Act. And Bart is going to lead us out with our 4 takeaways from our presentation.
Okay, 4 takeaways. Number 1, expect aggressive enforcement. Whatever you remember, Willie Sutton said, you follow the money, and that's where the money is. So you got well-funded, well-armed auditors, prosecutors and agents out there looking to aggressively enforce the act. Secondly, expect relentless prosecution by the SIGTARP for those who falsify PPP applications or spend the funds or misspend the funds or spend the funds differently than they were supposed to. Number three, expect whistleblowers to come out of the woodwork, because that's where it happens. When you follow that, when you see tremendous government money spent, you see the plaintiff's bar, the relator's bar, and it sprouts whistleblowers. And finally, as Elle said, take precautionary measures to prevent criminal and civil prosecution later. We've enjoyed presenting with you, and thank you for having us.
Oh, sorry. Yes, our last code word for the presentation is green. So
Okay.
you will be able to put those 3 code words into your survey and get credit for this CLE. If you have any questions, feel free to send them to us, because we do have a few minutes in the chat function, or you can email Bart or myself at one of these emails listed here. But otherwise, thank you so much for joining us this afternoon, and have a good day. And we'll stick around for a couple minutes in case any questions come in.